Welcome back to NCBA's Coffee Break, the place where we talk creditors' rights without requiring a full CLE session or even a second cup of coffee, though both are encouraged. I'm your host, Nathan Willner, and today we're recapping some key takeaways from last week's Ohio Creditors Attorney Association spring meeting, particularly where advocacy, legislation, and collaboration intersect. And I'm really excited to be joined today by attorney Crystal Duplay. And if there was a voice in that room that reminded everyone to stay grounded in reality, it was Crystal's. So, welcome, Crystal.
Thank you, Nathan. That might be a slight overstatement, but I tried to do what I could. I'm glad to be here and happy to discuss and not have to use PowerPoint.
Well, that's already a win that you don't have to use that clicker. But for our audience, Crystal is licensed to practice law in Ohio and Wisconsin, as well as before the United States Supreme Court. Her practice is long focused on creditors' rights, with experience spanning nearly every area of retail and commercial debt collection. She earned her undergraduate degree from Baldwin Wallace University and her JD from Cleveland Marshall College of Law. She's a frequent presenter at NCBA conferences and other industry programs. So we are excited to have Crystal with us today. Um, so let's talk about the session that you championed at the Ohio Creditors event. Your session focused on the realities of civil litigation, not the brochure version. So why was that important to you?
Um, this the topic came up. It's a frequently requested topic for our group, but I think it's good for colleagues to know that they're not the only ones experiencing this stuff. It helps train the younger, newer attorneys to the profession, and it serves as a nice reminder for some of the more experienced attorneys. And also, creditors' rights litigation isn't in a vacuum. Everything you do, even if it's right, you can still wind up with unexpected delays, evidentiary issues. You can have pro se consumers being pro se consumers. There are procedural hiccups. Clerk of courts, if they spell your name wrong, if they spell your client's name wrong, how to handle all of that. So you have to be prepared for things that may not follow your intended script.
And that honestly landed. It reinforces that success in this space requires judgment, flexibility, and experience, not just knowing the statute. And that was sort of you were able to give real life experiences in the litigation world. And that's sort of what the Ohio Creditors Attorney Association is trying to kind of present to its local members is to bring in even the new associates or people that are new to the industry. And so I really want to talk about how organized and well attended collectively the event was. And one of the significant discussions we had an Ohio State representative, Michelle Grimm, who is a Democrat and the co-sponsor of a pending medical debt legislation bill. So, you know, she would be kind of perceived as, leaning to the left, to the consumer protection side. But, what stood out from that engagement? Like, what did you see there that you hadn't seen before?
Um, During some of our sessions, this is the extent of interaction. But that wasn't the case when Representative Grimm was there. She was almost everyone in the room. There's questions coming in from we do a hybrid, so it's partially online and live in the room. And every people in the room were engaged. People were asking questions online. She and Representative Grimm didn't shy away from answering some of the difficult questions. She recognized some areas where creditors and consumers can benefit from potentially some of the same reforms. One of Ohio has nearly 300 courts, and they are not on a unified e-filing system, and some of our courts don't even have online dockets. So
And that is just amazing to me. And they have different filing fees, right, as well.
yes, yes. So one of the things I personally, and not as VP of the OCAA, would like to see, but personally, is a uniform e-filing system. And then if I'm going to get real greedy, I would also like to see courts embrace Zoom or virtual hearings more. Um, I think that it may encourage more consumers to appear at hearings if they can appear from their lunch break in their car. And then, as the industry knows, if you can talk to someone 9 times out of 10, you can get a payment plan.
Yeah, so it's really about communication. And I thought that, while again there may be some, within our industry that are not happy, with legislation that's restricting debt collection, medical debt collection in general, over 7 states already passed legislation like the legislation in Ohio, and it is a bipartisan bill. So again, it's hard to say that this is a bill that really leans left or right because there's 10 Republican co-sponsors as well. But what the part that I really want to talk about is that what we found is we agreed on most of the things with the representative, and it was like a win-win-win. Maybe talk about like how this would help um, the debt collection industry as well to have virtual hearings. Like it's not just the consumer side; it would help both sides, right?
Yes. So it would help the industry side, because you can have one place to log in. You don't have to manage a password data bank of 300 courts for every single attorney in your firm. You can have something centralized. Um, so it makes uh, everything easier to file. You don't have to remember this court, that court. Central place, one login, and then in Wisconsin, where I also practice, you can type in your name and it shows you all your hearings that from now into the future. So you can see every hearing that you have coming up, so you can be better prepared for them. Um, when, hey, I'm on vacation, maybe I should file my motion to continue this now. Maybe I should ask someone else in my firm if they can cover it. Um, it just makes everything flow faster.
So these are, not ideological issues. These are, procedure and policy kinds of enhancements and improvements that clearly both sides of the aisle can work on. But again, that requires talking to each other. So, and this is where the broader picture matters. Like conversations like these don't happen by accident. And this is where organizations like NCBA play a critical role.
Yes. Um,
Uh,
Go ahead.
No, I was going to say, how do you see that role working with the state creditors bar associations as well to kind of have these conversations?
I think that NCBA's engagement with state creditors bar is essential. It allows, well, issues to be identified at local level, like what we're seeing every day, to be elevated nationally. Um, if NCBA might know, hey, your neighboring state just went through this process. Let me put you in contact with their state creditors bar. Maybe they have some information about how their state pushed this, or how what the transition was like from them, so your members could be better prepared.
Yeah, and I also think being part of a national network of creditors' rights advocates, putting together stakeholders groups where it's the local folks plus national organizations from different disciplines within creditors' rights, it really amplifies the message. And what I've noticed is that legislators listen differently when the perspectives are consistent, informed, and coming from a coordinated community rather than isolated voices. So one person here, one person there, they might be polite, but they're not really, it's not going to really sit up and take notice. But when you see multiple associations, both statewide organizations and national organizations, including lawyers and creditors and chambers of commerce and other types of trade associations, makes a really significant difference, I think, in the way our advocacy works.
Yeah, I think best practices, education, professional standards, if we're all aligned, um, that voice is much louder than if it's several individual voices. Even if the individual voices have the same message, it's if you can come together, say we all want this, it's much more impactful.
Yeah, absolutely. And also, you also want to be out there as a resource to even legislators that you might ideologically disagree with, because if you stay in your own corner, there, nobody's going to understand what your concern is. Medical debt was a good example where, you know, one side said like, we need to do something. Medical debt's a real problem. Basically, it sounded like they wanted to do away with anyone paying for any medical care. On the other side of the coin, you had people saying, well, we want to get every, dime. But the reality is that the place where the conversation education made a big difference is by working on what the definition of medical debt was. Many of these pieces of legislation would have had a definition of, money paid on behalf of a medical debt. Now that could be to a credit card that you paid a medical bill on, or maybe it's not even a medical bill. Maybe it's just a bottle of Tylenol that you used your credit card for. So is the entire credit card now a medical debt? So again, having these relationships, being able to come in and say, look, we saw the writing on the wall. Many places we saw we're not going to be able to, modify the entire proposed bill. But where common sense did make a difference was when you explained that, look, you need to define medical debt as monies owed to directly to a medical provider. If you're going to start including, anything that's somehow related to medicine, but it's on a credit card, going to cause huge problems. So anyway, we're getting close to the end of our cup of coffee, so to speak, Crystal. And you know, if last week proved anything, it's that meaningful progress comes from staying engaged, even when viewpoints, differ. Last question. So after a full day of serious policy discussions, what's the real relief? Coffee, silence, or logging on to get the CLE credits?
Hitting the gym. No, it's it's probably a little bit of all three of those things.
No, but you mentioned a good thing. Taking care of yourself is also a very important part of being a responsible practitioner. So, people that don't know, Crystal is a really proficient exercise person, and I'll leave it at that. You want more information, you can reach out to Crystal directly. But anyway, Crystal, thank you so much for joining me today and your continued leadership in this space and everything you're doing for NCBA and the Ohio Creditors Attorneys Association. So thank you for joining us.
Thank you for having me. It's always a pleasure.
And thanks to everyone listening. This has been the Coffee Break podcast from NCBA, where collaboration matters, advocacy counts, and the coffee is always strong enough to get you through the legislative session. And with that, I'm Nathan Willner. Have a great day, everyone.